The report of day 2 of our faculty development program on the theme AI Law and Digital Society in India. Day 2 begin with the thought-provoking discussions on some of the most pressing legal and societal challenges posed by the digital era, particularly in the realm of online hate speech, misinformation, and content regulation. The day's first expert session was led by Dr. Nidhi Saxena, Associate Professor, Faculty of Law, University of Delhi. Her talk titled Regulating Online Hate Speech, Misinformation and Content Moderation was a deep dive into the constitutional and statutory framework that governs digital communication in India. Dr. Saxena detailed the provisions such as Section 196, 197, 212, and 353 of Bharatiya Nyaya Sanhita, along with the Information Technology Rules 2021 and the representation of the People's Act also. She discussed the various models of content moderation, including pre-moderation, post-moderation, reactive, automated, and hybrid systems, emphasizing the social and psychological impact of unchecked online content. She stressed the urgent need for robust legal regulations. Dr. Saxena also highlighted global perspectives such as the United Nations Global Principles on Information Integrity 2024 and US Digital Service Act, which obligates large platforms to remove flagged hate speech within 24 hours. She also contextualized challenges using case studies from India, including the farmer protest, Twitter takedowns, and Congress toolkit controversies also. The second session was delivered by Professor Dr. Pallavi Gupta, Head of Department of Law, JIMS EMTC, Greater Noida. Her presentation on cyber law in regulation of digital platforms explored the broader dimension of digital platform governance. She elaborated on the objectives of cyber law, from ensuring privacy and identity protection to preventing cyber crimes and securing digital rights. She outlined existing Indian laws, regulatory challenges on OTT platforms and social media, and emphasized the importance of a clear cybersecurity policy in the evolving digital framework. The day concluded with an engaging discussion and presentation session, which was moderated by Dr. Rumi Ahmed, Associate Professor in the Department of Law, JIMS EMTC Greater Noida. All the participants shared their views and delicate balance between the freedom of expression and online protection in India's digital society. So overall, day 2 was a stimulating blend of expert insights, comparative legal analysis, and active participant engagement, adding depth to our understanding of artificial intelligence and digital regulation in contemporary legal discourse. Thank you so much. Thank you, Ambika.
Thank you, Dr. Simivir, for that insightful recap of day 2. The discussions and sessions have been incredibly enriching, and we are excited to carry out the momentum in today's session. Now, to officially open today's session, I invite Professor Dr. Pallavi Gupta, Head of the Department of Law, to address the gathering. Please, ma'am.
Good morning, all. As the topic of the FDP is law, artificial intelligence, and the digital society. First, we have to understand what is law. Everybody knows that under Article 12 of the Constitution of India, what the law is. Law enacted by Parliament, circulars, notifications, ordinances, law by custom, recognized by law, precedent, judicial decision. Whether this law we have with reference to artificial intelligence in India, I think there is no law regarding artificial intelligence to handle the issues arises by the misuse of artificial intelligence in India. Although we have law in some extent to regulate digital society, we have some judicial pronouncement where Supreme Court or judiciary has given the directions to make strict law or new law to handle the issues arises by the misuse of AI or to regulate the activities of AI. Since the topic for the day is copyright, creativity, and the ownership in the age of AI and digital media. See, in copyright, the idea or the literature or the music or the science, the science of the dance performance, they are having ownership in that way. There is a recent case in the court of Greater Noida, District Court of Greater Noida. There is a case that it is challenged that the painting made by AI, who will have the ownership? Whether it is a different painting or it is a same painting. So the matter is sub judice. The argument made by the advocate is that since the idea of making that painting by artificial intelligence, which is already made by someone else, so in that way, artificial intelligence will not be the owner. The person who used the AI for their own benefit to make the painting, although what shall be the decision of the judiciary, it will come in the soon, or we will take time. But the matter is for the discussion. How AI can intervene the ownership with reference to copyrighted work. So with this, I hope today Professor Jelis Shubham, Head of the Department, School of Law, ITM University, Raipur, will deliver the lecture on this topic. I hope this lecture will be enrich the session and will educate on us. We will be educated on this point, the issues regarding to that. Thank you very much.
Thank you, Professor Dr. Pallavi Gupta, for your inspiring words. Your support and leadership have been instrumental in organizing this event. We are now about to begin our first expert session of the day, which will focus on the ever-evolving area of copyright law in the age of artificial intelligence and digital media. I'm pleased to introduce Dr. Jelis Subhan, Head of the Department at the School of Law, ITM University, Raipur. Dr. Subhan will be discussing copyright, creativity, and ownership in the age of AI and digital media, an increasingly important topic in the digital age. Professor Jelis Subhan has 29 years of professional experience. He started his career in sales with office automation industry and subsequently moved to FMCG industry, moving from sales to business development. The journey included 3 multinational corporates. Professor Subhan possessed a spectrum of academic qualifications, engineering, literature, and law. A master's in English literature and master's in law from the National Law Institute, University, Bhopal. Presently submitting his thesis for the doctoral degree at the National Law Institute, University, Bhopal. Professor Subhan was at the bar as a counsel for 8 years, appearing before various courts, district and session courts, high courts, Madhya Pradesh, Chhattisgarh, and Nagpur, Bombay High Court. Professor Jellis, since last 12 years, is into serious academics, establishing one of the best law schools of the region and leading the best upcoming law school at ITM University. Professor Subhan has been a resource person at various national and international conferences, faculty development programs, faculty orientation program of UGC, workshops, symposium, and more. He has been a trainer at Chhattisgarh State Police Academy for legal studies. He is a panel member of Doordarshan Prasar Bharati in the law department as well. He has published more than 20 research papers in various international journals of repute and presented more than 25 papers in various international and national conferences and workshops. He has got 3 chapters published in edited books, and he has conducted more than 40 workshops for school students relating to cyber hygiene, cyber security, and more. Apart from this, he has been a caring husband, a doting father, and he is an ardent follower of sports as well. We welcome you, sir.
Thank you so much. I think I am audible.
Now I would like to invite Professor Dr. Pallavi Gupta to felicitate our speaker of the day with virtual bouquet.
I welcome Professor
Thank you.
in Greater Noida virtually.
Thank
in
you.
fact.
Thank you. Thank you so much, ma'am. So,
My
wonderful.
heartfelt welcome to you.
Thank you so
My
much.
heartfelt gratitude to you, sir. Very good morning to you, sir.
Good morning.
Some
Good
other
morning.
time we will meet physically, sir, in Greater Noida.
Sure.
But this time virtually, I welcome you, sir.
Sure. Thank you. Thank you so much. Thank
Thank
you so much. So I think we should start. Hello. Am I audible?
Over to you, sir.
Okay, fine. So, good morning to all the participants, all my colleagues, I should say. I'm not here to teach you anything, and I can see a good number of people who are well experienced sharing this FDP, and it is a great opportunity given to me by the
Sir,
organizers.
good morning. I believe your mic means you have to unmute, sir. Could you please check? I will
No,
also
I have
check from this
unmuted.
place.
I have unmuted myself. I have
Sir,
unmuted.
let me check. Let me
Please.
check, sir. I believe some technical glitch.
You're audible, sir. You're audible, sir.
Okay, I'm audible to some, but not all.
Now it's okay, sir. Please proceed, sir.
Audible, sir.
Yes. Now is it okay? Is it fine,
Yes.
sir?
Yes, sir. Yes, sir. Absolutely.
Okay. So, first of all, I pay my gratitude to the organizers for giving me this opportunity to discuss on this wonderful topic of copyright, creativity, and ownership in this digital world. So, before we start, there are 3 elements which are incorporated in this topic, what I feel is that creativity, apart from copyright, creativity and ownership. So it says that there are three elements which are the part of this topic. So it becomes imperative to know what actually copyright is first. Then what do we mean by creativity? And third, by ownership. And all these end up premises or premised over the digital world. That is what the topic given to me says. So let me start with a brief discussion on copyright, and then we will move into creativity. What is creativity, and the concept of ownership, all coming in this age of AI and digital media. So AI and digital media, very separately, I will be discussing what is AI and what do we mean by this digital media, though it seems to be overlapping to each other. Whereas we start with copyright, uh, before doing this, let me hello.
Hello,
Hello.
sir. You are audible, sir.
Audible. Huh? So, can there be someone who can prompt me whether if I am audible or not? Suppose in the course of time it happens, because there are something which is popping up on my screen.
Sir, you are perfectly audible. Please
Perfectly
continue.
good.
Sir, it is audible. It is audible, sir. You kindly proceed, sir.
Sure. So let us begin with a brief understanding on what is copyright. So there may be lots and lots of discussions. Every one of us, if we belong to the domain of legal knowledge, we know what is copyright. But there are certain aspects, just to, as a matter of revision, we should look into that copyright is a kind of a legal protection or which guarantees rights to the creators over their literary and artistic works. Literary works like novels, poems, books, etc., even it includes computer programs. Similarly, it also protects dramatic works like plays or choreography, etc. Third element of musical works, maybe a composition of songs, lyrics, etc. Furthermore, artistic works, when we say artistic works, it includes paintings, drawings, photographs, and then sculptures made by the artists, and even it includes architectural works. Furthermore, copyright protects cinematographic films, which includes all sorts of videos created and saved on any material, right from your CDs or the tape. So that includes cinematographic films. And the last will be the sound recordings. All the sorts of sound recordings recorded on whatever material is also copyrightable. So, having said all these things, these are works of arts and literature which are protected under copyrights. Different definitions are there given under the statutes. Section 13 per se provides for works in what I had already discussed, works in which the copyright exists. Similarly, if we say of copyright, what actually that right is? Once someone has created, obviously have an exclusive right over the work or created by the author or the artist. But what right? In fact, what is that right which comes along with that creation, which we say has been protected under copyright. That per se is to have the reproduction rights, exclusive right to make copies of that very work, what has been created and has been protected under the Act. Similarly, the distribution rights, the right to distribute those copies of work, the original work which has been created by the author or the artist to the public. Performance, the right to perform the work publicly for certain types of works, because performance is related with dramatic work, or you can say cinematographic film, or those kind of things that can be performed and also displayed. So it also includes display rights. So right to display the work publicly for certain type of works. Similarly, adaptation, the right to prepare derivative works based on original work. And moral rights are also included into this, these rights which are provided by copyright protection. Having said this, there is a certain duration also. The duration of any copyright work is the life of the author plus 60 years after the demise of the author or the owner of that copyright. What does it actually provide? Copyright provide for? It promotes, the second aspect is that it promotes the creativity and innovation by providing incentivizing the creator of this copyright work of art, work of literature. And this is one of the most, not one of the most, it's the most ancient right which came into existence, which was recognized through the statute of NA. So, and it was related with copying of original work. So from that very initial point, we have come so long, so far to have now a kind of performance rights also included as a part of copyright. When we say of these literary works, what is the requirement that which kind of work shall be provided a copyright protection? That comes into discussion thereafter. When we come to know about what are the works which are copyrightable, there comes that now we need to discuss what will be the basic requirements for these works to be protected under copyright. So the first and foremost eligibility is that these works should be original works. Original works means a work created or done by the author or that artist in question, by himself, by using his own skills. So originality of work is the first requirement. And it's a foremost requirement also, because even if something is not original, you say a development has been done on any existing material also, then also if it was due with all permissions or all other requirements which the Copyright Act says, it is also copyrightable. Like if something has been with due permission of that original work has been adapted into a certain other work. Like for example, a writer has written a small piece of literature, maybe a drama, and that drama or that play is adapted into a movie with due permissions. Obviously, with due assignments and due permissions, it is required. Then that second original work, or not the original, the second work, which is a derivative of the original work, is also copyrighted. So it will be considered as original work, but not as an original work which had been adapted. Rather, it will be a work adapted, a derivative work, but in creation it is the first creation. Similarly, there may be other creations also of that very same original work, very same original story. But every time a new derivative work comes into existence, it is copyrightable, but the basic requirement in all these derivative works shall be the element of minimum modicum of creativity. That there must be something which makes it different from that original work, and it is an improvement on that work. So even that can be copyrighted, and it is a copyright protection is available for that. And one more most important aspect of copyright is that copyright is such a protection which subsists in the work itself. So if you say if you write any sentence, for example, any simple sentence, does copyright exist into that? Yes, it exists. Then when I say copyright per se exists in the work itself, then what is the requirement? Why it is required to obtain a protection under copyright? That becomes a question. Why? That is only if a copyright protection is applied for and obtained, it only provides a prima facie evidence that the work belongs to the person who has obtained a copyright over that work of art. And in the contrary, it depends upon the person alleging to be an infringement to establish that the work does not belong to or is not the creation of the person who is having this copyright. So in a way, copyright protection, if someone has not taken a copyright protection, that does not mean that the work created or the work written, any literary or artistic work which is done by an author does not have a copyright. It has a copyright and it belongs to the author of that work. But registration of copyright is only for establishing that legally this work belongs to the person who has obtained a copyright. Otherwise, if challenged and established, that copyright may be revoked also. So these are some fundamental aspects of copyright. When you say what kind of exact right existing in the work, for example, if you take a novelist, the novelist or a writer of a book has a copyright in the book which prevents other from copying, distributing or creating a movie adaptation or etc. without his permission. But suppose I purchase a book. Books are available in the market. So what exactly I have purchased? I have not purchased the copying rights of the material which is written in that book. I have not purchased a right to adapt that very information which is provided by that book. Rather, I can use that
You can
information.
see a lot of that attitude in me. You will find more
Oh.
colleagues like me, non-interfering, and they're busy with their.
Yes, okay, someone was saying something.
All the participants are requested to kindly keep your
No, if at all someone has any question, or we will be addressing it in the end of my talk, that will be better.
Yes, yes.
Huh? Thank you.
Yes, sir. Sure, sure.
Thank you so much.
After this session.
Yeah, thank you so
Yeah.
much.
Thank you so much, sir.
So, when I was saying of a writer of a book, he owns the copyright of that book, and I have purchased that book from the market. What exactly I have purchased? I have purchased the right to read that. Even I can use that information in any further work which I create. And but I don't have a right to transform that information into another kind of work. Now, here is a difficult proposition what I have to transform. Like I cannot, like there is a story, suppose, written in a novel. Without the permission of that author, I cannot make a movie out of it. I cannot make a painting based on that very story. Right? But I can read, I can see, I can whatever informations are given in that book, I can use those informations in creating a new work. And this usage of information becomes infringement of copyright only when due a reference is not given. Like suppose I am taking up a doctrine given by someone, or a kind of, not doctrine per se, some information which provides some data, and I'm taking that data from the work of someone else, and without giving a due reference, proper reference, or proper acknowledgement to that author, and I'm using that data, then it becomes a copyright infringement. But suppose in that book, there is certain informations which enhance my knowledge, and even in and then I create something new which has that very basic minimum modicum of creativity, and it is a new creation, totally different, and maybe resembling to a very small extent to that original work, is not an infringement of copyright, will be actually a new work and will be copyrightable, and the copyright shall be provided to the author who has created this new work. Like for example, the very leading case of R.G. Anand decision, which established that ideas are not protected. Only expressions are protected. So, and it is very general, it is very common that people living in different part of country, or living apart, or two different people living in different areas may have a same idea in their mind. So what is copyrightable then? Copyrightability lies in the expression of that very idea into into something which is tangible, in a tangible form. When that idea is expressed in a tangible form, it becomes copyrightable. But the same idea, maybe without any knowledge of such existing work, may come up in a very different part, and then there will be a question to decide the originality of that work. But suppose there was no connection between these two persons who have created, and they have no idea or no access to such pre-existing work, then it becomes very obvious that the new work is also copyrightable. So the discussion and the debate still goes on on these areas, whether and how far it will be decided the existence of two expressions based on a very similar idea. But largely, the judgment of R.G. Anand provides that it is only the work, only the expression of that idea which is copyrightable. Similarly, if when we move to musical compositions, now musical compositions, it starts with lyrics. Again, the idea of writing a lyric or a poem may also have similarity. Unknowingly and innocently, it may also happen that I may also have a sentence or a group of words written in my poem, which may resemble exactly to the earlier work. Then what will be the idea of copyrightability? Then again, it raises a question, how to decide and how to differentiate between two lines. Like, for example, there may be hundreds and thousands of words which are very commonly used in all famous Hindi songs. There may be a number of songs using similar words, similar connotations, but every work has something different. And again, that very test is applied, that any connection between the two or any similarity because of prior knowledge, or is there any presence of minimum modicum of creativity? Again, this minimum modicum of creativity was established by a D.B. Modak case. As students of law, we know everything about these two leading cases, D.B. Modak and R.G. Anand, I said. So the idea of copyright, again, is extended by including the work of originality and the concept of creativity. The iota of creativity makes any work, and even the smallest element, also provides copyrightability to any work or artistic work. Then if we discuss about paintings, now there is also a huge chance of getting similar paintings or paintings on general knowledge, general ideas, and even paintings based on the very artistic thought of the painter or imaginary propositions of a painter. Like, for example, there are, first let us take about the existing informations, like existing stories also. Like someone paints a painting of Shakuntala and Dushyant and Shakuntala. It's a common story which is read by almost every student in their childhood. And if they have read that story, they know the various aspects in the various events in that story. Sorry. So a painter paints a story depicting a scene from that story or anything which may be related to that story. I must say it is not an infringement because the story already is beyond the copyrightability time frame. All right. Though if we were able to recollect who had written that story, even then it is something which is beyond the protection provided by copyright, since it is time immemorial from where we know this story. So, or for example, you take up the story of the tortoise and the hare. Every kid knows that, and even all the elders know. Now, if someone paints that story depicting the very famous race between that hare and the tortoise, not coming up with that established morale of that story, rather giving it another twist to that. Maybe something which may be related with managerial acumenship, like the one who plans, do the planning, do the planning or and executing that plan in a stable manner will win the race, rather than who haphazardly puts his attempt or tries to put his effort, and then after sometime do not take away, do not carry on with that zeal and zest and think that he has more or less achieved. So it's a time to relax. So it can come up with different morals. That very story or that very painting can come with a different moral. Now, what will be the position? Will that painting be copyrightable? Obviously, it will be copyrightable. And similarly, there may be other ideas also. But in every work, the crux of deciding whether it is copyrightable or not, or it is an original work, rather, it's an original work or not, depends upon the creativity, the element of creativity involved in that very work. Similarly, the softwares or the photograph or architectural designs, they all come up as original works only when it is created by the author on his own as an original work, having minimum modicum of creativity. Originality is the crux of this copyright. Having said all these things about copyrightability and originality of the work of art, there are certain aspects in copyright also which provides exemption from infringements or exemptions from copyright per se, that the copyrighted material can also be used for certain purposes where it has to be established that such a use is done it is considered as a fair use. That a copyrighted book, like what I was discussing earlier, the informations given in a book can also be used directly for research. And under this, there is an exemption, which is called as fair use. The exemption from being categorized as infringement. So for the purpose of research, or even for the purpose of criticizing any work, if that work is used it also comes under the purview of fair use. Like, for example, we as a country are also signatory to the Marrakesh Agreement, Marrakesh Treaty, which allows the copyrighted works to be adapted into different modes for the use of people having vision problems. So, if a work, and if as a signatory to that treaty, it provides an exemption to the copyright infringement from adaptability to such a condition, to such works or such books which are made, which are accessible to the people suffering from blindness or from a visual impairment or otherwise visually disabled. So if those works or a copyright work is transformed into those kind of works, like a book is transformed into uh, that braille kind of thing, that into that system of hello. Unfortunately, I lost the internet connection. Now I think I'm back and audible too. All right. Hello.
Yes, sir, you are audible.
Yes.
Thank you.
There was a break in my internet connection. And now I am back, I think. So I was just discussing how a copyrighted material can be adapted or transformed into another uh, mode, making it accessible to the people who may not have that kind of accessibility towards a copyrighted work. Like a book can be transformed into braille, a book can be brought in with a bigger font, or even a book can be written or published with different colors, which a colorblind student or a person with color blindness or that kind of inability can also read that book. So similarly, a book can also be transformed into a music, audible books. So these kind of adaptations are also included under the fair use concept of copyright. So that can be done. Thereafter, it comes how ownership of copyright can be transferred. Because when you say it as a intellectual property, a property per se, a property has certain features. Any property has certain features, like possession of that property, usage of that property, and then alienation of that property. How that property or that ownership in that property can be transferred. So even copyright as a property, as a right, we know that uh, it can be transferred to other people, and it can be done through licensing. A license can be issued by the owner of the copyright to others to create or to have those very rights which we have discussed in the earlier part of making copies, distribution, adaptation, and whatever. And those rights will be mentioned in the license, and that can be um, given to other. The owner can transfer the rights through license. And even secondly, it can be transferred through sale, like selling of the copyrightability. The copyrights can be transferred through sale or one-time emoluments. You can say that it can be transferred to others. Similarly, a copyright is also succeeded that the successor of a copyright can also have the benefits arising of from that copyright, but not in the very sense which the owner, the original owner had. So that is also something which generally it can be, it comes to the successor of that copyright owner, but not in that sense of which the original copyright owner had. Limited for some limited purposes, for enjoying the, for example, for enjoying the payments or enjoying that royalty which is coming to them, and that is also till the 60th year of the demise of original author, not beyond that. So during that, they can also assign that work, licensing and assignment and sale. By assignment, it is very much limited for a certain work, like adaptation. If it is set for adaptation, so an assignment can be given by a copyright owner. Suppose we take a novel, adaptation only for making a movie, that can be assigned. A right of adaptation to make a movie can be given to any other person. And similarly, these assignment rights which the owner can give is not necessarily limited to one person. It depends upon the contract which is given to the person, the contract of assignment given to the person by the original author. The contract may include and also may avoid multiple assignments. Like suppose a singular a contract of assignment is made between a person willing to adapt that novel into a movie, and another person comes who is trying to adapt that novel into a drama, which was earlier a prose. Now he wants to adapt it into a drama. So separate assignments can be given. And if the contract does not say to the contrary, even for making films, subsequent assignments can be given. Like, for example, any famous novel, like if we say The Guide, it's a novel. And that novel would have, the author would have been able to give the or issue an assignment, a contract of assignment to a number of people to make films. If with the first contract, it was not to the contrary. If the first contract of assignment said that no, or it restricted that no further assignment shall be given to any other person, it would have stopped there. Similarly, for different works also, assignments can be given. And even licensing is also related with creation of duplicity or multiple copies also it can be given. Then transfer of rights has another aspect too. The transfer of copyrights is having another aspect, that who will be the owner when it is created under a contract of employment. Then who shall be the owner of that work? The landmark judgment in R.K. Lakshman, Manorama pocket books, it came by the Honorable Supreme Court. A new proposition was laid down, and it was to find out whether and what kind of contract existed during the creation of that original work. Whether it was a contract of employment or it was a contract for employment. Sorry, it was contract for service or contract of service, not employment per se. I just missed on that word. So it is contract of service or contract for service. Like if the person who has created an artistic work was under a contract of service, whatever is created in such a contract, which is also called as employment, contract of employment, shall belong to the employer, not to the employee. Because whatever has been created during that, under the course of that contract of service, shall belong to the owner, or the ownership shall belong to the employer. Similarly, on the other hand, if the work of art is created by a person under the contract for service, the ownership of such a copyright shall belong to the person who has created that. Again, this is something which remains debatable. Sometimes it remains debatable, or sometimes it has been questioned in other cases, like in the Viacom industry case against sorry, Sunil Grover versus case versus Viacom industry. How many of you actually know, have ever heard of this case? Viacom industry, Sunil Grover versus Viacom industry? Hello? Hello?
Yes, sir. You're audible, sir.
I just asked, is there anyone who has ever heard of the Viacom industry case or a Sunil Grover case? It is one and the same. No one. Okay. It was something which was related with another creation of a fictional character. Now that fictional character, the question before the court was, who owns that fictional character? Most of us know and most of us watch that TV show, or TV, not a TV show, it's rather not a soap, it's a show, Kapil Sharma show. And there was a character which was played by the artist Sunil Grover. And that work, that creation of a fictional character came into question, that who is the owner of that fictional character. Though the court had actually, the dispute was settled outside the court, but seeing at earlier judgments, we can comfortably say that it is based on the contract of service or contract for service. Suppose it was a contract for service, the person who has created during that course of contract owns that very creation. So the rights of the person who has created is till the extent when he has created it under, not under an contract of employment or contract of service, because for at that instance it will be the employer's right to have a copyright on that. Furthermore, copyright is a territorial right, but by having international conventions on that and being a WIPO member, the copyright or these rights are provided the same protection throughout the signatory countries. So the new developments or new inclusions or new extension of copyright is now we can find it in performers' rights. So a performer creating anything or performing in a certain manner, and that mannerism belongs to the very creator of that, or that very person who has created that, and it is also now protected. For example, you can have a peculiar style of doing something, like maybe an artistic move, or even a move in sports, or a particular style of playing, a particular style of performing, that is also now protectable under copyright as performers' rights. So no one can no one can create, or rather it is something which comes into existence through a series of recognitions which can be appended to that certain particular style. For example, that helicopter shot which Dhoni used to play, and it was appended to Mr. Dhoni, that this kind of cricketing shot is played by Mr. Dhoni. So it got attached to that, it got affected, it got recognized with Mr. Dhoni, that very particular shot, or that kind of cricketing shot what he played. If suppose that would have been protected under performance rights, then without due approval, without due permission, no other would have been able to hit that very cricketing shot, or you might have hit or might have played that cricketing shot, but without having said that it is Dhoni's whatever shot of that helicopter shot. So it might be very different. So maybe previous to Dhoni, there may be different players who might have executed that very kind of cricketing shot. But it was not never attached to that particular player of that very sports. So that is something which comes to our uh, consideration for performers' rights, a kind of vocal even rendition may be protected under performance rights. The second aspect of this talk or of this topic was about creativity. Now, what we have seen through discussion in our copyright is that it is something which is purposed to incentivize the creativity of an individual. But what is creativity? Creativity is something which can be defined as an ability to create, to generate new ideas, concepts, and imagination. It comes out of imagination, human imagination. And then something or some work of art which is created through this, which is definitely a new idea, a new concept, which has brought into existence by the creativity of a human being. Now here I'm saying of human being. Further, this human being is also being replaced by a machine. So creativity basically, as I said, is premised over fundamental aspects of originality, novelty, imagination, innovation, values, flexibility, and elaboration. Like when we discuss this originality, this means that something creativity is to create something new and unique, which has been non-obvious or which hasn't been seen by anyone, which hasn't been known by anyone. Then you can say it is original. Similarly, novelty, very much similar to originality and runs side by side to originality, which says that it is a fresh, a kind of thing which is unprecedented novelty, like it has never been found, never been thought, and never been felt. So something new has come up. It means novelty. Thereafter, all this creativity is because of imagination, the ability to envision things, how things can be done. Maybe a simple imagination of combination of colors. That is also based on the very idea of imagination, that how a combination of different colors can be made, which looks or which creates a sense of admiration, which definitely will be original and which will be also possessing novelty in its vision, in its impression. So that is also that is how imagination can create. Secondly, it must be kind of creative ideas which are put into some tangible things to create, to innovate something new. The word itself, innovate, says that some innovation has come, maybe or on existing knowledge or even without any existing knowledge, but maybe an idea which has the capacity to be implemented or to be constructed in a tangible form. So that can also be called as, that can also be a part of creativity. Similarly, the different perspectives can be accumulated, different approaches can be included, and a new idea can be created. So these flexibility and elaboration, which means that how to elaborate on a very smaller idea and then refine that idea to make a useful machine or a technology. So that can also be elaborated. So creativity is based on these very ideas. Creativity, in fact, is not something which is the prerogative of artists or inventors, but it is a skill for everyone. You know, even the ordinary man or a common man can be very creative. Though the creativity of that very person may not be identified and may not be incentivized, but creativity remains. Like I say many a times that it is not the inventors who are creative. Rather, a common man, because of his requirements, necessities, also create. I also demonstrate this art of creativity. So, but on a larger extent, we must conclude into that creativity may be there, creativity is with every person, every individual, but there are certain essentials also to this creativity. Like for the first instance, for having these elements of creativity, education is a must. Education moves towards expertise on that very subject. And then it creates an imaginative and thinking mind, which eventually creates. So it requires an intrinsic motivation. It is never extrinsic. Extrinsically, one can be forced to create something, forced to do something. But in a larger sense, it is not the concept of creativity. Creativity comes through expertise, which requires a strong fundamental knowledge of any skill or in a particular area, which can skill in a particular area, which makes the possessor of such expertise to create something new. There we can find the overlapping of expertise or even in context with expertise, and then imaginative thinking skills becomes another novel idea to promote creativity or to uh, protect and encourage creativity. Imaginative thinking skills are foremost required. Then some sort of adventure is also an element in promoting creativity. Creativity largely comes from the inside, from intrinsic motivation is there, though certain times it is also found extrinsic motivation, but largely it is intrinsic motivation. Like, for example, if I am inclined to paint, I will definitely paint. Maybe my initial painting may be of no intellectual or intellectually, they may be very poor. But gradually, once I get influenced by the existing knowledge or the work of art, I may develop into something more reasonable and more, what do you say, more recognizable, that it has been created, a new creation has been done. So the idea of creativity is a fundamental requirement for uh, the topic of copyright. So it is something which is fundamentally required, that there must be a creativity element, an element of creativity creates subject matter for copyright. So having discussed these two parameters, like what is copyright and how creativity is essential to have a protection under copyright, the question comes of ownership. Who shall be the owner of such creativity, which is though copyrightable also? So who shall be the owner? Who will be the owner then? Or what is ownership? Ownership of a work has certain rights. We should learn ownership from the jurisprudential aspect. And the jurisprudential aspect creates ownership as something which provides a legal right. It is a legal right which provides for possession, which provides a control, and which provides a right to dispose of or right to alienate that very property. These are fundamental legal rights which come along with ownership. Are you getting my point? How many of you are really listening to what I am saying? Can I have a
Yes, sir. Of course, we are paying attention to, it's a very nice deliberation, sir. We are paying attention.
Thank you so much.
Thank you, sir.
Thank you. Thank you. So ownership, when we say, is a legal right for possession, providing possession and usage also. Ownership also provides that the usage of that very object or of the very subject matter is also with the owner. He can possess, use, control, and also alienate that owner, that property which he owns. And the most important aspect of this ownership is also a right, which is a right to exclude. So that means the right to exclude is that the owner has this fundamental right to exclude others from enjoying that property, interfering with that property, or even entering into that property. A right to exclude, and similarly, a right to alienate. So these are the parameters, these are the rights, or you can say the concepts which are very much uh, very much aligned with the copyright. So copyright, when we say that it's a bundle of rights, so though there are different rights which I had already discussed, it also it is also related with, rather it must be said that it is complementing the concepts of creativity as well as ownership. Correct? So ownership now further provides a right to transfer also. Ownership rights can be transferred to others through sale, gift, or other legal instruments. Ownership, in a difference from your copyright, which we were discussing, ownership may be perpetual. That means as long as the owner wishes, it can be limited by specific terms. It can be owned by the owner. It can be, the duration of ownership can be shortened by assigning that ownership to someone else, or even by passing on that ownership through means of gift or succession or sale. So it can be done. Similarly, what should be the distinction? And what is the distinction from possession and usage, ownership? Can anyone answer to this? What is the difference between ownership and possession? Possession is the act of holding or controlling a property. That means having a full control over that property, how to be used and whom will be allowed to use. And that is an act of holding. That means it is in the possession of the holding person or the person who is controlling that property, while ownership is the legal right to that property, for which a tenant has possession of rented apartment, but the landlord remains the owner. Are you getting my point?
Yes, sir. When a person has a title over a property, it can be said as an ownership. But if he holds any physical or constructive control over that property, it would be regarded as a possession.
And when you say title, it is a legal right. It should be legal right. Right?
Yes, sir.
Title is recognized by law. Then only it becomes a legal right of ownership. For example, you can say a tenant may have a possession of a rental premise, but the ownership remains with the landlord of that premise. Correct?
Yes, sir. Yes, sir.
But there was ownership in the concept of ownership. There is also a difference between the Roman law and the English law. According to the Roman law, the first we discussed on control and power over a thing. That was the first principle, which is according to the Roman law. Whereas the English law focuses on bundle of rights, which we discussed later on. Like ownership, according to the English law, is a bundle of rights which says a right to possess, a right to use, a right to alienate, and a right to exclude. So four kinds of rights are obviously there under the English law system, English legal system, which says that ownership is a bundle of rights. Whereas if we come to the Indian laws, particularly the Hindu law, according to ownership, according to Hindu law, ownership is recognized through possession, prescription, and inheritance. So again, the three elements which are similar in the English law are recognized by the Hindu law of ownership too. This concept is very old, concept of ownership. Like when it was a nomadic society, there was a primary concept. That means everything possessed by the community or the group of the people had access. All the members of that tribe or the members of that society, nomadic society, were having equal access to all the possessions of that very nomadic society. But with the advent of agriculture, or you can say when the settled society came into existence, settled communities came into existence, the idea of ownership became more prominent. And they were associated rights, there were associated rights and responsibilities also came into existence. When we moved from nomadic society to settled communities. So that is how we can understand ownership. Now comes the most important aspect of what do you mean and how we can relate with the second part of the title, which said copyright, creativity, and ownership in the age of AI and digital media. Everyone nowadays are saying AI. Everywhere you find AI. Very fascinating word, AI. What is this AI? What is this AI? Artificial intelligence. Correct. How can you, and where we can find this artificial intelligence? What is all about artificial intelligence? Or what is the basic understanding what we are having related to artificial intelligence? Can anyone just express what do you mean by artificial intelligence? Any attempt? Attempt to define artificial intelligence.
So in this, the data is collected and through the predictive analysis of such data, the machines are able to make decisions just like humans.
Just like
Just like humans in a way, but of course lacking the empathy and the emotional intelligence.
artificial intelligence. How many of us, I think every one of us have used calculator, correct?
Participants are also encouraged to participate.
It will be a good idea because since 1 hour, 1.5 hours, I'm speaking to the screen. I think I'm speaking to the wall, to a wall. No one is except a few. Yes. So I think every one of us has used a calculator. Is there any intelligence in calculator? No.
Yes.
Yes.
Participants are also encouraged to write in the chat box. And sir, you may also check the responses from the chat box.
I can see someone has written, yes, sir, yes, sir, right to exclude other from possession and the ninth point of ownership. Very good. So everyone has used a calculator. Calculator, what is calculator? Calculator is also based on in artificial intelligence. That is a simple algorithmic function. What it does only a kind of algorithmic function. It compares the data and brings out a result on that very data. Now, how come we are now so very much prominently saying about artificial intelligence, AI, and AI everywhere? Artificial intelligence can very simply be defined as a thing which is an algorithmic calculation or which is based on logical formulas, logical conclusions, which is done by a machine, and then it comes out with a result. So comparing a data and giving out a result. That is what we were supposed to do in a calculator. When the data or when the digits were fed into that calculator and the command was given either to multiply or add, the calculator used that algorithm and then it came out with the result. Now, that very basic algorithmic calculation has grown to such an extent that now it is handling a huge data, which is again it is fundamentally working on the feeds. Whatever has been fed to the machine, though now it's a huge data with a more developed and advanced algorithmic calculation, logical conclusions, logical calculations, it is now possible to chef out, which was never imagined to be done by a machine. So it is only something which has been created. It is not going to do anything on its own except when given an instruction. But now with this AI, there has been the scope of instructions, the scope of logical reasoning has been developed to a huge extent. Like you can never imagine now how it is functioning, because it is functioning because we have made it to function. Like when I am saying this, or we are discussing all these things, and our cell phone is kept here. The AI in my cell phone is hearing to whatever I am saying, whatever we are discussing, and then it will start its own individual prompting, and it will try to find out logical answers to whatever we have said or we have discussed. Having defined or having said so many things about artificial intelligence, let me also tell you this artificial intelligence works only based on the data which is available to it. And therefore, we are also continuously saying that there are developed AIs are also coming into existence. Some came up with ChatGPT, and then there are certain developed advanced features, and advanced features are also coming. But every artificial intelligence, or how the machine is doing these calculations, are based on predefined data, predefined promptings, and a huge informations which are there. So by comparing those informations, it is giving out a result. But suppose I say, if a wrong information has been fed to the AI, then what will happen? Can it control the very existence of human beings? Some people are saying that it may control even the existence at a point of time. It may be controlling the even existence of human beings. So it may turn into a Frankenstein. But I don't think so, because as far as we take up this AI as a tool to help us to create knowledge, or to create an easiness in general functions of our society, then AI is a tool, a mere tool, which is very efficient and very we can be relied upon for exact answers and exact conclusions. Now, coming back to the entire topic of copyright, creativity, ownership in the age of AI. Now, why we are saying of in the age of AI? Like what I discussed about copyright was a work of art or literature. Creativity is an ability of a human being. Ownership is something which is a legal right. And all these are now being discussed in the age of AI. Age of AI is that now human beings shall not only be confined to their own intellect for creating any new knowledge. They may be using machines to create a new knowledge. That is where the concern arises, that what will happen to creativity? Can it be now devoted to human intellect only? And secondly, who will be the legal owner, or the ownership shall lie on whom? whether it will be the individual person, individual human being, or the machine. That is how we need to understand this very topic of creativity and ownership in the age of AI. Because copyright, to understand copyright, it is a statute, it is a law, it's an intellectual property right, which is recognized by a statutory provision. And whatever comes under the definition of copyright is copyrightable. The question, larger question is, what will be the extent of creativity and what and who will be the owner of such creativity? Because we are having now a tremendous tool in our hand, which is artificial intelligence. Whereas another portion of digital media. So digital media is something which is related with computers, which is related or expressed with digital. So whatever is now created, earlier when we said that copyright, as we discussed, copyright is also on cinematograph, films, and software programs, and all those tangible things where the expression of an idea was made. So nothing difference is there, only uh, the tangible element has now included a digital platform, which is expressed in the form of or you can say form of um, logical that what do you say, anything which is expressed in 1 and 0 bits, that becomes digital. And digital, even digital, can be stored on a tangible format, and even it can be on a cloud. So fundamentally, there is no such difference. A media, a print media or a digital media, the only difference is that a print media is a hard coming into something which is very tangible on a paper or a book or any other material, whereas it is electronically stored data, which we say of digital media. So the concern is over creativity and ownership, which uh, is now challenged while using this concept of artificial intelligence. Now, artificial intelligence, as I said in the very earlier, that it is nothing but uh, something based on different algorithms and logical reasoning and logical conclusions, which is carried out by machines having huge data or a big data handling capacity, which can be done by only machines. And these machines or these it's a tool which can be used to create. Like for example, AI is can be used to create uh, create a living being also digitally. Like there may be, or like you say, a person who might have gone from this world hundreds of years ago, but whose inputs we are having the data, like a photograph or how he used to uh, his face, how his face was, how was his mannerism, and we, if we put all those things into a machine, which is supported by artificial intelligence, it can create a visual, a model of that very person, and it can show it to speak into that very kind of accent or very same language or say having same mannerism. So that is how AI can be used. But the larger question is, who is creating this? AI is a mere tool. Who is creating this? AI itself can never create unless and until it is prompted to do so. Like, for example, a robo in a house is programmed to perform in certain manners. Like if suppose nowadays it's becoming very common that robots are used in a household, that it is and the robot will be there doing the babysitting, then may also be taking care of uh, cooking some food, maybe some food. Then it is actually programmed for all those activities. So it will be continuing to do that. And while having so many data, the scientists are now also having a fear that it may develop emotional intelligence also. So that remains it remains a distant question. Correct. But presently, when we say of creation, when we are discussing in the context of copyright, it is only a creation of work of art, literature, drama, cinematograph, whatever has been defined under Section 13 of the Indian Copyright Act. If anyone or anything which is mentioned under this Copyright Act is created with the help of AI can only be considered as a tool. So my conclusion is that the person who has used this tool is the real owner of the work of art as far as copyright and creation of all these works is concerned. So it may not be said that artificial intelligence in its own can be considered as a person, right? So maybe if suppose a problem will arise when a robot or a machine using AI will create something on its own. So that is a distant thing that it cannot create anything of its own until and unless it is programmed and prompted. So my take on this issue is that AI remains only a tool to create something and to extract some knowledge, and based on that human intellect shall prevail over all these, because in the end, I must say that whatever artificial intelligence comes or whatever is used as a tool to create something which can be copyrighted shall nowhere take away the ownership rights of the individual. Correct. And then artificial intelligence will always be in a conflict with natural idiocy, I should say. Right. So natural idiocy is also an element which creates. It is nowhere necessary that only a standard of intelligence or a level of higher intelligence is required to create anything. Most often, we can find the creations may be done by anything which was not so very intelligent, an act of intelligence. Rather, it came out because of an idiocy or done by someone. So, for me, I don't think that beyond usage as a tool, AI shall have any effect on the creativity or ownership, though it may. Obviously, if you are using a good tool, creativity will develop. And if you are having good information, creativity will definitely be developed. But in the end, it will be the human intellect which shall prevail, and ownership obviously will be with the person who has created using whatever tool or to whatever extent the usage has been done. So I think I have come to an end what I wanted to discuss with you all. So I can take up questions, and I have seen some chat box also position, some new things have popped up.
Yes, sir. Dr. Rumi has asked, if a
Ah,
tattoo design is created on the wrist of Mr. X, can Mr. X claim copyright of that design?
can Mr. X claim? Now the question comes, how, why you have created a tattoo on Mr. X? First thing is, why you have created this, the design on his wrist. Was it under a contract for service, whether Mr. X had paid you to create something? And if he has paid you to create a design on his wrist, he is the owner of that copyright. He can claim that copyright. Otherwise, if you have created something on his wrist without his permission, then it becomes problematic. And in that case also, it will be, it will belong to Mr. X, right? So if I enter into someone's compound and I plant a mango tree, it does not mean that the mangoes will belong to me, right? I hope I have answered your question.
Yes, sir. Thank you so much, sir. Any other questions from the participants? You may ask through chat.
Yes, the second question is very interesting. Since AI acts as a human being and AI created an artistic work painting which is already done, who will be the owner? So this is the question which is still in contention because, you know, as I said, AI cannot create anything on its own until and unless it is prompted to do so. Now the question arises, when it has created on its own, then who shall be the owner of such work? This is still to be settled by the court of law. But if you say, if you take my own, my understanding is that when we say that AI cannot create anything on its own, the one who has prompted it to do so shall be the owner. Yes.
Yes, sir.
There is another question. Please explain regarding copyright of works on mythology. Can you please clear upon this? What do you mean by works on mythology? If you say that you are related with mythology, means like Puran or Ved or these kind of things or text. Dr.
Good,
Smrita. Yes,
good morning, good afternoon, sir.
good
First of all,
afternoon.
I would like to thank you for your informative session. Actually, sir, I have one doubt. As
Yes,
you
please.
talk about ownership, uh, is there any country in which, or any particular case in which artificial intelligence assisted or AI created works are defined or clearly distinguished from each other? Because
There
of
are some convention countries which are working on it. You see, I was just reading a few days ago, some European countries, I think, had done, but I'm not clear at this point of time. I can come back to you with the exact data and exactly what has happened. It was related with some European country or US a few days ago. I was just reading that, but I'm not able to recall that. If you give me some time, I can come back with that. Because
Okay,
someone has
sure.
done
Thank you.
some country has
Right,
decided
right,
on that, but I don't remember.
right.
Huh.
Thank you, sir. Thank you, sir. Thank you so much.
So stories written by author, please explain regarding copyright on works on mythology. If you say on the works of mythology, like the stories related with Shiv and Mahadev. So there has been lots of novels coming on that very story of Shiv or Mahadev, you can say. Because all these texts and all these stories are already in public domain, and it is long. It belongs to a prehistoric time. So none of the copyright existed, right? Suppose as a hypothetical position, if we take Tulsidas Ramayana, even then Tulsidas was there in the 16th century. So long ago that has gone. And I can tell you one thing very interesting thing was a book written by Karl Marx, Das Kapital. Correct. Every one of us know Das Kapital. And there is another student of law who has written Das Kapital around 2013-14. I've used that very title, Das Kapital. And it was published in Delhi. I think it was in Delhi. And since that original Das Capital had exceeded the protection under copyright, so that even that can be used, and that we have done that. Yes. In the digital age, how can copyright laws effectively balance the rights of creators? Simple, it remains the same. That whoever has created, it will be with them. And if you say of public access to knowledge and innovation, there is a concept of fair use and fair dealing, right? In our law, we say fair use. So it can be for the purpose of knowledge and innovation, it can be used. So it is an exception to copyright. So it exists then, and at the same, can the person who is getting the tattoo printed becomes a copywriter? This yes, he will be there, because if that print is on the wrist of that person, and if he starts, because obviously, if he is the owner, he has the right to replicate and right to make a copy of that. So even that can be done. Ethically when utilizing the data, especially in the situation not fully understand. Yes, this is a larger question, that how we can. This is again similar, very similar to the ethical position of a man in in a real world. How ethically AI can be restricted, because again the question arises: what you are creating? If you are creating in the content with the help of AI, and it is not ethically correct, then obviously it has to be restricted by all the laws. All right. An ethical situation will become bad when the AI starts operating on itself. Then there shall be a problem. And then also my take will be, if the machine has been designed and has been fed with these unethical portions, then you have no check on a machine which will be unethically doing and unethically playing rather with the data which has been fed into that machine. So that depends on the very initial instance. Then only we can effectively address, even on this aspect of privacy concerns are there. The technology now has actually infiltrated into the privacy of individuals. And on this, my take is that technology has made state like what the Pegasus, yes, Pegasus was the thing. So the state now has actually uh, Yes. So, what my take was that now the technology is now in the hands of the state. Now, state has an access into all your privacy using that technology, like what we had witnessed in the matters of Pegasus. Like, so it is more or less with the state to protect the privacy of the individuals. There may be n number of artificial intelligence and machines will be coming, but it remains with the state. No individual can do. Individuals are vulnerable in this case. Similarly, if you see in even on this AI platform or even in this cyberspace, anyone can enter into my laptop and can plan something offensive. Then where privacy is not only related with my personal data, it is also related to my machines. So it can be accessed by anyone. So it's a very dangerous situation. And in this dangerous situation, it is it is the state which shall come to protect all the individuals. Yes.
Good afternoon, sir.
Good
Sir, am
afternoon.
I audible?
Yes.
Sir, my name is Priyanka Negi, research scholar from Himachal Pradesh National Law University. Sir, first of all, I would like to thank you for your insightful session. And my question is, sir, as we know that AI can now generate fake research papers, falsified data, and even fake legal notices. From copyright and ownership perspective, how do we differentiate between creative use and criminal misuse, especially when intent is hidden behind automation, sir?
No, it's a
This is my
different
question.
question you are asking on the very first stance. Copyrightability is something very different. And you
Okay,
are
sir.
saying of illegal notices, correct?
Yes, fake legal. Yes, sir.
Fake legal notices. Okay, let
Yes,
us
sir.
begin with fake legal notice. Fake legal notice or a legal notice, and both of them in the context of copyrightability.
Yes, sir.
If something is fake, copyrighted is related with a work of art.
Yes, sir.
Let us
Yes, sir.
understand it first, right?
Yes, sir.
Then
Yes, sir.
comes your a document, fake document. Fake
Yes, sir.
document, if AI is creating, then it is a matter, something very different. It will be an offense in under IT Act.
Okay.
है ना?
Actually, sir,
So,
research area is related to a use of artificial intelligence in commission of crime.
so
So,
that is very
yeah, yes,
yes,
sir.
it can be there because
Yes,
someone
sir.
using AI, it
Yes,
will
sir.
replicate the original thing. The
Yes, sir.
copyrightability does not arises on anything which is created with a wrong purpose.
Agree, sir.
Like for
Agree, sir.
example, there is an exception to copyrightability also. Like what can be copyrighted? It also includes no matter which can be disturbing in nature, like anything against public policy, public decency. You cannot
Yes,
claim
sir.
a
Yes,
copyright on
sir.
that. So similarly,
Yes, sir.
it's a criminal offense. Correct?
Yes, sir.
Yes.
Yes, sir. Thank you, sir.
Thank you.
Sir, I have a question.
Mhm.
Sir, my
हाँ
question
जी,
is something different. Just a query
हाँ,
of my query just is
हम्म,
that since in copyright there is a performance right, correct?
हाँ,
So the judges who give their decision, eh, the judges
हाँ,
who gives the decision, final decision, it
हम्म.
comes into the whether it will come into the performance right.
The performance rights is fundamentally related with the mannerism, with
Yes,
the
correct.
style, with the mannerism, what kind of moves. Like there may be a certain move. Like for example, in a dance performance, there may be a certain move. Like yesterday, I was watching Birju Maharaj. He was doing the duck walk.
Okay.
Have you ever seen the duck walk of Birju Maharaj? If you get
Duck walk,
opportunity, please.
सर बिरजू
Hmm.
महाराज का डक वॉक नहीं देखा, बट जो योगा करते हैं तो वहां जरूर देखा डक वॉक.
हाँ, so you see
जी सर.
Birju Maharaj duck walk, and
Okay.
definitely it's a part of performance rights,
Okay,
because
जी sir.
Birju Maharaj is actually a classical dancer, and in its classical dance, he was performing the duck walk. Now, this is something very special. Now, this can be associated, this can be appended with the name of Birju Maharaj. It's available on
Okay.
YouTube, and accidentally I saw it yesterday. So it was such a thing that you could have never imagined a classical dancer doing a duck walk, and
Yes,
that
sir.
to the stature of Birju Maharaj. So those kinds of mannerism, even if you say, if in the context of a judge delivering a judgment is not itself a performer, something performance, you can say. That is a part of his duty. He is doing that. He is not doing a performance per se. But suppose there comes a, like you say, have you seen that umpire, a cricket umpire from New Zealand?
Yeah.
He used to make different gestures, and he was not raising his finger for declaring out. Rather, he was having a twisted finger like this for giving out to a batsman. So that is a different manner. Mannerism is different, right? So style or a mannerism, that is protected under performance rights.
Sir, sometime, judiciary, the personality of the judges, correct? When we are talking about the style, so the personality of the judges, we say, yes, judge के court में गया तो very strict decision आएगा, इस court में गया है very liberal आएगा. So the personality, the way of the giving judgment by their personality will come into the style.
Personality per se does not come unto performance rights.
जी sir.
But the mannerism, like some people who like the walk, the gait, rather the gait, how a person walks. The gait can be a matter of performance rights, obviously, because the way, like anything, how he walks, or like putting out a hand before speaking. So that can be done. That comes under the context of performance rights.
Okay, thank you, sir. Thank you very much.
Thank you. Anything else or?
Hello.
Yes.
Good afternoon, sir. Myself, Vipul Kumar. I have a very
Ji.
simple questions as I have been like teaching last since 7 years. So I just wanted to ask the question related to the same topic in a practical manner. That is, how can education system prepare student to understand and navigate copyright issue in an, am I audible?
Please continue.
Yeah. So how can education system prepare student to understand and navigate copyright issue in an AI driven world? So this is my question. So sir, just can you?
How education can, if I'm able to understand
How can education system prepare student to understand the navigate copyright issue in an AI driven world in today's era?
Very good. Very good. Vipulji, first, my take will be, first, let us have a ecology, a kind of education ecosystem in our classes, that the students are made to read and understand what is copyright. Right? First step should be, let us understand what is copyright and what the act says. There are two things: concept of copyright, and another is what the act says. The third part of this reading will be related to the judgments, what and how the courts have interpreted different provisions of copyright. Once the students are capable of understanding the copyright concept and the provisions of law and the interpretations given by the courts on different matters, on different aspects, then comes the introduction to how AI can be used to construct, to make things, to create any work of art. Since we are saying copyright, work of art, how AI can do. Then comes three major questions. What shall be the extent of usage of AI? Like suppose I am writing an article, and to write that article, I need certain informations. And I use AI to give me those certain informations, and I'm taking those informations and writing my research paper or my article. This will be the extent of usage. Or I am saying the AI to write an article for me on this topic, premised or taking on all these areas and the word limit and the paragraphs and etc. etc. If I have fed into the AI and I have created everything. Third will be, what will be the ethical question of using AI, because informations may be unethical, ethically wrong. What we are trying to find it out from the use of AI, what we are doing to which extent. So that will be the second question. And if suppose a student is able to identify these three areas of usage of AI, to what extent and to what is ethically correct or ethically wrong, and third is which is legal and which is illegal, because there are also concerns which are illegally or concerns which are legal or which are not legal or illegal, directly defined as illegal. Like you cannot use AI for the purpose of creating of making a bomb. So if the student is doing that, then again the question arises that you have crossed that limit. So this is how it can be done. So you have to understand both the things. First, understand copyright, what copyright is. Second, to what extent you are using AI, and to for what purpose you are using AI. Then only this can be done.
Thank you, sir. Thank you.
Any other questions from the side of participant? Thank you, sir, for the enlightening session on copyright, creativity, and ownership in the age of artificial intelligence and digital media. Before that, I would want all the participants to turn on their cameras so we can take a group photograph. All the participants are requested to turn on their cameras. Lily. Okay, thank you, sir. Your expertise and perspectives have helped shed light on some of the challenges that the legal world is facing in today's AI world. Now, I would like to invite Dr. Komal Chauhan to give the vote of thanks for this session. Please, ma'am.
ना वो क्या कहते हैं, उसमें सॉकेट में कोई दिक्कत हुआ, कोई दीवार का निकालेंगे ना, हमने उससे कनेक्ट करके चलाया।
आप एक तो चलाना।
अब तो सर डॉक्टर लागे वही
Ms.
जो
Amrita, for inviting me to deliver the vote of thanks. Good afternoon, everyone. On behalf of the Department of Law, GIM City, and it is my privilege and honor to extend a heartfelt vote of thanks for the enlightening and thought-provoking expert session delivered by Dr. Jailis Subhan, Head Department of Law, ITM University, Raipur, on the compelling topic, copyright, creativity, and ownership in the age of artificial intelligence and digital media. Sir, your insights into the evolving landscape of copyright in our technologically advanced world and the challenges and opportunities posed by artificial intelligence and digital media have not only broadened our intellectual horizons, but also equipped us with a deeper understanding of the legal nuances and ethical responsibilities in this domain. Your expertise has inspired us to rethink the traditional notions of authorship and ownership, appreciate the delicate balance between innovation and protection of rights, anticipate the future contours of legal frameworks in the digital era. Further, it would be a remiss not to recognize the unwavering support and academic vision of the chairman, Sir Dr. Amit Gupta. Your commitment to fostering excellence in higher education is instrumental to programs such as this. I also extend my gratitude to Professor Dr. Sachin Yadav, Campus Director of GIMS, whose strategic leadership ensures a vibrant learning environment that supports advanced academic inquiry. Special appreciation is also due to Professor Dr. Pallavi Gupta, Head of the Department of Law, for her exemplary guidance and for advocating faculty and institutional development initiatives that encourage progressive and research-oriented legal education. I would also like to acknowledge the active engagement of all the participants and the audience whose thoughtful contributions made this session both rigorous and impactful. I once again thank you, sir, for sharing your valuable time and knowledge with us. We look forward to more such enriching engagements in the future. Thank you so much.
Thank you so much, ma'am.
Thank you so much, sir.
Thank you, ma'am.
Thank you, Dr. Mohammed Chauhan, for your heartfelt vote of thanks.
Thank you once again, ma'am. Can I leave now?